Hi everybody, it's Andy and welcome to my office in Modesto, California. I'm an attorney licensed to practice law in California as well as New York. In this video, I'm going to go over attorney trust accounting. Now the idea of attorney trust accounting is not unique to California, it's not unique to New York. Attorneys in other states in the US use attorney trust accounting also. I actually don't know whether or not attorneys in other countries use trust accounting. If you are an attorney in a country other than the US, let me know in the comments below whether or not trust accounting is used in your country or not. Regardless of what country we're talking about or what state we're talking about, the idea behind trust accounting is pretty simple, I think. But the thing is, it's just relatively rare. Like the average person, who hasn't dealt with attorneys at all, really doesn't have the opportunity to get exposed to trust accounting. So the thing is, because it's not a common thing, it is kind of difficult to understand at first glance. So I'll illustrate the idea of trust accounting by kind of drawing an analogy to a checking account. So a lot of people have checking accounts. Not everybody does, but a lot of people do. And the checking account, maybe you get your paycheck deposited there. Maybe you pay your rent from there. You pay your mortgage. Your car payment, for example, your insurance, your credit card bill, etc. And at the end of each month, maybe you have some money left over, you put it into your savings account, and next month, the whole cycle just starts all over again. The idea then is that there are basic transactions that, are transactions that come into the bank account, or into your checking account, and transactions that go out. All of the money that goes into and out of that checking account belongs to you. An attorney trust account is basically a checking account that basically operates just like a normal checking account, except all the money that comes in and all the money that goes out either belongs to the client or is spent on the client's behalf. So a couple reasons why you might want to have a trust account and use it. For example, let's say that there's a settlement in a lawsuit, for example. You're the client, your lawyer has worked on this case, the case is settled. A bunch of money has been paid, but the thing is, in order for you to actually get your portion of that, the attorney has to subtract out, expenses, the attorney's fee, for example. A trust account is very helpful in doing that. Another reason why a trust account might be used would be, let's say that it's a divorce case and the client has prepaid $5,000, for example. And let's say, for argument's sake, that the attorney works at $250 per hour. So that's 20 hours that the client has prepaid. Those 20 hours, the attorney is probably not going to do all 20 hours at one time. So the thing is, that 20 hours might be kind of spent over a month and a half, 2 months, something like that. The unearned portion during that time has to sit in the attorney's trust account because the money is there, then the attorney controls it. However, it's not the attorney's money yet. So as a result, he cannot keep it in a bank account that has his own money in it, for example. So in California, there are the rules of professional conduct. I have a separate video that actually goes over that. So I'll go ahead and link that right over here in case you haven't seen it already. But the rules of professional conduct govern things that lawyers can do, can't do. That basically they're bound, like lawyers are bound by that simply because they are lawyers in California. Trust accounting and mixing of the attorney's money and the client's money, that's called commingling. All of that is gone over in Rule of Professional Conduct 4-100, which you can go ahead and basically find by looking at that video. I'm also going to link Rule 4-100 down below in the description for you. So hopefully all that made sense. The idea behind commingling funds, or not commingling funds, I guess, keeping funds segregated. It's very easy to keep funds segregated. It's very, very common, unfortunately, for lawyers to mix funds improperly. If you are ever so inclined, I'm sure you could find news articles and California State Bar articles and stuff about how often lawyers get into trouble because of commingling. So again, hopefully all of that made sense. The idea behind an attorney trust account is that it is basically a separate checking account that the attorney can transact out of, can receive money, pay money, but all of that money is the client's money. It's not the attorney's. So the attorney has to keep very good records, of a ledger or Excel spreadsheet or something that details how that money in the trust account comes in, what it goes out, and what it's spent on, etc., etc. So hopefully all that made sense. I'm going to go ahead and answer two kind of common questions about trust accounts that probably a lot of people don't answer for some reason. I'm not quite sure why. So the first question basically pertains to interest. So if, for example, we go back to that divorce example that I mentioned, if the client has prepaid $5,000 to the attorney, and the attorney is not going to earn all of that, for like a month or two or three, the $5,000 might accrue some interest, and the client might kind of logically wonder, hey, well, that money's mine. You're holding on to it, Mr. Lawyer, but that money's mine. Shouldn't that interest go to me? And the answer in California is unfortunately no. And the reason the answer is no is because the bank that has the trust account, that bank will be in communication with the California State Bar, and any interest that accrues on the trust account funds in a given month goes to the California State Bar. Now the good news, of course, is that the California State Bar does not spend that money on itself, rent or salaries or lobbying or anything like that. That interest money goes to the California State Bar, which then uses it to fund pro bono programs, legal aid, other types of services that benefit the people of California generally. So that's the first question. You as the client do not get the interest. The second question is probably most pertinent for lawyers, and basically the idea is, how do I open a trust account? I know that I have to keep, the funds separate, because of Rule 4-100. How do I open a trust account? Can I just use a regular checking account and keep it segregated, keep really good records? Is that enough? And the answer to that question is also no. When you open an attorney trust account, you actually have to explicitly open an attorney trust account. You have to find a bank, they're like most national banks will have this. But the thing is, you have to find a bank, you have to go in, you have to explicitly say, I want to open an attorney trust account, please. And if your experience is like mine, you might have to go into the bank a few times. Attorney trust accounts are not new things by any means, but they are, again, sufficiently rare that I think a lot of bankers who work at bank branches probably don't deal with them all the time. You may, like I had to, go to the bank branch a couple times to find a banker that actually knows about attorney trust accounts, knows the process to open them, etc. So hopefully all that helped. The basic takeaway from this video is that an attorney trust account is not, like it sounds intimidating, it's actually not bad at all. It's just a separate checking account that the attorney keeps the client's funds in, and it's useful for storing money that the attorney hasn't earned yet, or facilitating settlement, distribution in the event a lawsuit has settled. So hopefully all that helped. Go ahead and rewatch this video if you want. Comment, share, like, subscribe, all that stuff. And I will talk to you next time. Thanks.